Hey everybody, can you hear me? Yeah, it works this time too. Yeah, let's see here. So, I think it works this time. I'm still talking to nobody, but also somebody. Hey, Steph. Guess I should go ahead and get started. There's definitely plenty of nonsense to talk about. I'm gonna wait for people to get here. I thought we could go over some of my past favorite sentences. I said you. No, I didn't say that. You're right. Okay, good. Okay, I can't. I can watch myself on tape delay. That's even worse. Chat here. Okay, that's better. I can manage this. Okay. So just to give you an idea of what we're dealing with here. This is Sergio Kitchen's, Ghana, I think? Yeah, Ghana's sentence. And this was the first thing I ever tweeted about right here. Shall not commit no criminal acts. Nothing's getting revoked. Antonio Salmon has the same thing, but he also shall not have or possess no guns. Shall not commit no criminal acts. And here we have it. Young Thug's motion to revoke probation. That's my puppy. And yeah, this is actually, it was written by Adam Abate, who wrote the Misconduct probation revocation petition, which I've read a few times. And there are a lot of similar mistakes and half-truths that are in this one as are in Misconduct. So I think the problems with this one are a little bit harder to find, but they're essentially, they're just as much there. So let's see. That's not how you spell Jeffrey Williams, first of all. I didn't notice that. I haven't read through this in any detail yet. I just skimmed it once, so that's not how you spell Young Thug, right? Am I crazy? Yeah, that's not how you spell his name. So maybe they're trying to revoke somebody else named Jeffrey Williams. That's probably the smartest possible explanation for what this is. Okay, so state of Georgia versus somebody who isn't Young Thug. Comes now, the state of Georgia, by and through the undersigned council, it moves this honorable court to immediately revoke the probation of defendant not Young Thug. Not Young Thug has demonstrated a blatant disregard for the law, the safety of witnesses, and the integrity of judicial proceedings. The state submits that the defendants, who's not Young Thug, continued presence in the community under probationary supervision presents a clear and present danger to public safety and undermines the rule of law. That's a pretty broad, yeah, Danielle, I saw that. That's a pretty broad statement that his mere presence undermines the rule of law. I don't think he's in Georgia either, so a dude in California is undermining the rule of law in Fulton County. That one's kind of true. Also, it's the continued presence in the community under supervision presents a clear and present danger. So I guess if they just stop supervising him, they'll be good to go. Okay, on Halloween, with no spaces, the defendant, not Young Thug, was sentenced to probation with conditions that include no contact with the victim and the victim's family. I don't know why that's in there. That's not relevant as far as I remember. The defendant pled guilty. He also pled no to some stuff, but anyway. And the conditions of probation were imposed pursuant to, that's, yes, 42.835, which authorizes courts to establish and enforce conditions necessary to protect the public and uphold the administration of justice. Kind of true. Since sentencing, Not Young Thug has engaged in conduct that directly threatens the safety of witnesses and prosecutors, compromises ongoing legal proceedings, and warrants immediate revocation of petition. Probation. Okay, well, let's see if they talk about any of this stuff. I'll highlight this real quick. Let's see. Witnesses. That one's there. Ongoing legal proceedings. All right. Have to keep it green. Okay, there we go. Escalating threats and witness intimidation. And then the very first thing is about the investigator, but okay. Investigator Marissa Viverito, using investigator lightly there, is currently testifying in a multi-defendant gang murder preliminary hearing. Somebody murdered a gang? That's concerning. Which remains ongoing and is set to reconvene on... Okay, if it's set to reconvene, it's probably not ongoing. That's just a thing. Anyway, it remains ongoing and is set to reconvene on Monday, April 7th. That's the day of the next hearing, too. During this hearing, the one that is on April 7th? Okay. During this hearing, the court explicitly ordered that the witness not be shown on television while testifying. Okay. Not be shown on television. Despite this order, a known blogger deliberately violated the court's directive by posting on social media, which isn't television, she doesn't want to be shown on screen while here she is, along with a photograph, not television, of investigator Viverito. Okay. On Tuesday, April 1st, Jeffrey Williams, not aka Young Thug, amplified this act by reposting the image, not on television, with the caption, "Marissa Viverito is the biggest liar in the DA's office." Now, I gotta say, I don't know if I can go with Thug on this one. That's a lot of competition. I mean, the biggest? Hey, Matt, and numbers. The first time I streamed, I just started typing back in chat to the people who were trying to talk to me. I kind of forgot the concept. Trooper Paul for burrito is an interesting trade. I have to think about that one. Let's see. Marissa Viverito is the biggest liar in the DA's office. This post quickly went viral, amassing over 2 million views with thousands of comments. Yeah, I'm not surprised it's not accurate. I mean, it's not an accurate statement, but viral with thousands of comments and retweets, many of which included... We're going to come back to that, too. Many of which included direct... That's another one. Threats to investigator Viverito and her family. Direct threats. As a direct consequence... See, Abate, he does this constantly. He does this all the time. He does a heading that says one thing. I'm not talking from experience. He does a heading that says one thing, and then he changes the wording slightly in the actual text. He plants the idea in your head that he's going to talk about something, and then he talks about something else. It goes from direct threats as a direct consequence. That's not the same thing. That's a completely different thing. As a direct consequence of these social media posts, it was one post. Viverito? Somebody's house. Somebody's home address and her parents' home address were publicly posted, exposing them to grave danger. Who posted them? It's passive voice again. Yeah. One post stated, I didn't know posts could speak, but if the hate is really real, then pull up on her mama crib. Along with a photograph of her mother's residence. That's not a threat. It's A, it's conditional, and B, it's talking to somebody else. So that's neither. It's also not a direct threat. Direct threats as in the verb. Like he's directing threats in their direction. I suppose that's probably closer. Hours later, an additional post emerged. It emerged? Threatening the assassination of District Attorney Fonnie Willis. It's a frightening emergence. The escalation from targeting a testifying witness to making a direct death threat against the elected District Attorney of Fulton County is a grave and unprecedented attack on the justice system. That's something. Okay. Pattern of intimidation in court undermining. This is not an isolated incident. It didn't happen, so that's true. It is part of a calculated It was a calculated campaign of intimidation, harassment, and misinformation designed to undermine the legal process. There's a campaign. It's a calculated campaign. They got spreadsheets, a calendar, they got everything. It definitely wasn't just a tweet. And also designed to undermine the legal process. Why would he want to? He's not even on trial anymore. Social media has been used as a tool to manipulate public perception, spread information, and instill fear. Yes, it has. These efforts have also included attempts. This is my favorite part. I get to do this right now. We're putting this in green. Okay. These efforts have also included attempts to exploit the court's perceived stance of disdain toward the state by referring to Your Honor as YSL Whitaker. How does that even relate to any of this stuff? Yeah, Britt, it can't. I'm sure he does, Creed. I'm not surprised. This ongoing manipulation of public perception. What ongoing manipulation? It's one tweet. What's ongoing? Public perception through social media is intended to obstruct justice. This just said this sentence: to obstruct justice, silence witnesses, and threaten those who enforce the law. This is just this. It's just this sentence again. Anyway. Great. Now we're to legal basis for revocation. I'm pretty sure there's not going to be a legal basis for revocation in here. Under that section has to do with revocation. A court may revoke a defendant's probation when they engage in new criminal conduct or violations that threaten public safety. That's not true. Criminal conduct, it needs to be a felony in most cases, unless it's a general. Actually, I shouldn't say that. Yes, crime can violate a general condition of probation, but that would only get you revoked up to 2 years at the most. And violations that threaten public safety, I need to check actually. Let me see that. This is Thug's sentence conditions. So yeah, this is the part, no violations of criminal laws, avoid injurious habits, avoid persons of disreputable or harmful character, community supervision, work faithfully at suitable employment. Never done that in my life. Do not change your place of abode, legal dependence, submit to drug testing, wear an ankle monitor, drug abuse treatment, sanctions, and restitution. I don't see anything in there about violations that threaten public safety. But I guess they could do that, but it doesn't seem like what Judge Whitaker did. Anyway, the defendant's continued association, nothing in there about that as seen so far. Continued association with individuals actively involved in witness intimidation, threats of violence, and obstruction of justice. This is just, you're just saying this 3 times. It's the same thing. Witness intimidation, threats of violence, and obstruction of justice constitutes a clear violation of probation conditions. Okay. This one's number 5. Yeah, I could see that being avoided. I could see that being avoided. Yeah, I should pull out the initial tweet. That's a good point. Let me see. Where was I? Okay, so there's a thing called due process. It's in the Constitution a couple times. It means that you can't just throw people in jail. I guess not. You can't just throw people in prison for no reason. You can't revoke probation without taking certain steps to, protect that there's the rights of the defendants. With respect to revocation in Georgia, you need to notify the person who's subject to revocation of the specific condition that was violated. And for example, let me see. What's a good one to see here? Oh, let's see. Okay, so he's Thug's banned from the Metro Atlanta area. If he went to, I don't know, the Metro Atlanta area and he was on a video there and the state saw him and wanted to revoke his probation, they would say, you violated condition 1A, and this is why we think you did that. You went to Atlanta, here's a video, and this is why we're trying to revoke your probation. You can't just say you were a dick on Twitter and I don't like that and it hurt our investigators' feelings, and so now we're going to revoke your probation. It doesn't work that way. You don't necessarily have to say it as explicitly as 1A, but it needs to be clear what specific condition you are revoking, or conditions. Oh, this one made me mad too. Hold on, let me pull this up first. I'm going to get the code section up for you. Come on, Westlaw. Okay. All right, here we go. Okay. These actions mirror the established tactics of criminal organizations. What actions? Isn't it just a tweet? These actions mirror the established tactics of criminal organizations as defined under 16-15-3, which is the gang code, this Gang Act section 16-15, which are designed to, you just said this exact thing, which are designed to instill fear, silence witnesses, and interfere with judicial proceedings. He said that's the 3rd time he's used that, basically that exact phrase. Okay, so he says criminal organizations as defined under 16-15-3. Let's see if there's judicial proceedings. He said that's the 3rd time he's used that, basically that exact phrase. Okay, so he says criminal organizations as defined under 16-15-3. Let's see if there's judicial proceedings. He said that's the 3rd time. Sure, I have that right. Criminal organizations as defined under 16-15-3. Let's see if there's judicial proceedings. Sure, I have that right. Criminal organizations as defined under 16-15-3. Let's see if there's Sure, I have that right. Criminal organizations Okay. So you can hear me here, but not in the other one? Okay. Well, we got through that anyway. I'll have to fix that later. But yeah, so this defined term, where was it? Right here, isn't actually defined. Oh, I know what it is. It's probably picking up my from my webcam on my on the other view. That makes sense. So yeah, criminal organization is defined under 1615.3. It's not defined under there, which are designed to instill fear. I'm not reading that again. As a direct consequence of these actions, law enforcement resources have been required to that doesn't make sense. Law enforcement resources have been required to provide security in response to the escalating threats and intimidation. I don't know how they're escalating threats. And up here, they have 3 things within a couple of hours. So I don't know how they escalated. And it was also law enforcement providing resources, not law enforcement resources. Anyway, Georgia courts have consistently upheld the revocation of probation for conduct that endangers witnesses, obstructs justice, or threatens public officials. That'd be a good place to put in a citation. I can't remember seeing any or many revocations along those lines. And I've read a lot of them. Let's see. Failure to act decisively will only encourage further attempts to threaten, harass, and intimidate those involved in this case. I assume he's talking about the other case, not this case. This case is the YSL case. I assume he's talking about the 4PF case. I don't know, though. The state asserts that not... You're going to say the same thing, aren't you? He's going to do it, isn't he? The state asserts that not addressing this matter directly with the defendant would fail to serve as an adequate deterrent, given the gravity and escalating nature of these threats. He's right, that not addressing it would not be a deterrent. That's technically true. Furthermore, as both the defendant and this court acknowledged, during his plea and sentencing, the defendant wields significant influence over people worldwide, amplifying the potential impact of his actions. I can't... That was the legal basis section, right? Yeah, he didn't actually identify a condition to revoke. He might be clairvoyant. Actually want to check one thing real quick. Well, no, I'll have to fix the PDF thing for later. Okay, let's keep going. So I'll mark this one for... Didn't get any case law or really any statutory law. We got the year of the hearing wrong. I didn't even notice that. That's right. He's bad at getting years right, actually. Yeah, that could be Danielle. That would make sense. I don't think that she was talking about that specifically, though. I think she was more so talking about, like, lyrics. Did you write October 25th? No, it's Halloween. Oh, 2025, yeah. Moonchunks was 13 years the 18th, I think. But a year before that. Need for revocation. The integrity of this court and the safety of those involved in this prosecution. That's also not right. The other prosecution is what I'm talking about. The defendant's probation should be immediately revoked to prevent further harm, ensure compliance with the law, and send a clear message that witness intimidation and threats against public officials will not be tolerated. That's still not a reason that justifies revocation. The state urges this court to take swift and decisive action by revoking the defendant's probation and remanding him into custody without delay. Wherefore, the state of Georgia respectfully requests that this court schedule a hearing to address. This court schedule a hearing to address, immediately revoke, or modify the defendant's probation as it deems appropriate. It's supposed to be to immediately revoke? Or to address, comma, immediately revoke? I don't know. Okay. Modify the defendant's probation as deems appropriate. Order the defendant to reimburse the costs incurred by law enforcement for the additional protective measures necessitated by their actions. This is supposed to be his actions, I guess? And impose any further sanctions necessary to safeguard the witnesses, prosecutors, and the integrity of the judicial process. He doesn't actually give any authority as to how the court can sanction him further. It's not as if he's on trial here, or even before the court. That's like a second layer due process thing. Also, there's nothing in here about prosecutors. Respectfully, you know what? No, that's not respectfully submitted. I'm sorry. Yeah. Still not the worst that I've ever read. So I'm surprised she signed this. They got this right. That's good. You think she would have usually have to say who you're actually serving. Why does it say defendants? All of them? What case number is this? I'm surprised by that. I think it would just be him. But maybe it's all the RICO defendants. What was that? Sylvia Viverito's testimony footage. I wonder if they watched the whole thing. Okay, so that's the original. Now we have biggest liar in the DA office. And are they saying that he, like, screen capped it? Oh, I see. So he just screenshotted it. And then he didn't use her name. And she lied in the hearing. Somebody said they misquoted him, right? Sorry, the one image that was massive threw off my whole thing there. What did he say? Marissa Viverito is the biggest liar in the DA's office. Oh, that's the problem. That's not good. Yeah, that's not good. Yeah, I wouldn't expect it to be served on anybody else. That doesn't surprise me. It wouldn't surprise me either way, but I didn't think it would be. Let's see. All my own. Wait, is this just Thugger Daily? Why is that there? It's not even... Why did they put that there? It seems like this guy probably didn't like her before this post. Dumbass used to live at altitude and got my Airbnb shut down. Okay, this probably isn't good. I wouldn't recommend doing this. Let's see. It's a screenshot of Thug's Twitter when he retweeted Thug Daily. Ah, I see. I mean, all those, like, this picture's right here. This one's posted by the police department. That's their picture. So that's probably the worst possible. Yeah, I wouldn't consider that one a threat, Danielle. This is probably the worst picture you could use to make your point. Also, sorry, I meant to get to this sooner. I think they really thought through the consequences of what the really, really funny consequences of what this revocation petition could go. Because he's, if it gets this far, he's permitted to have an evidentiary hearing. And he can call witnesses with, just as you could in any other hearing. So that means he could call pretty much anybody from the YSL prosecution team, meaning he could put Love on the stand, he could put Glanville on the stand, Hilton, he can put Viverito on the stand, he can put a bunch of other investigators on the stand, and I don't know if they want to do that. Just days of examination from Steele and Adams or whoever else he gets. And it's a thing that they're absolutely going to lose because they're not even alleging a violation. I would like to see that. I mean, I really wouldn't. I'd like it to just get dismissed or something like that, but I am not certain that they want to go there. I'm sure they just didn't think about that. They think they're just going to get somebody to roll over, but that's not going to go well. Yeah, and he can say, I think you lied about the watch, and then just ask her about the watch or anything else you think she lied about. Yeah, that's true. Owners of homes are also public record, yeah. I will personally make sure, okay, I'm not saying this out loud because I don't want to get taken out of context. I'm not getting clipped. But no, Allie, I don't think they'll really, if there's a hearing, it's going to be pretty quick. I don't even think Whitaker's. Yeah, she might. That's a good point. I think she's going to be unhappy with this, especially the Miles Farley thing, if that gets to her first. I think they're just going to keep antagonizing her, Judge Whitaker. They're trying to, Megan. I don't think it's going to work. Don't tweet this, and I'm not reading this. But I don't know who this is. It does have Snake in the name, though, so probably definitely YSL. Just making sure it wasn't a retweet. This is the transcript of his Thug's guilty plea, his little. It's on April 1st. I'm going to do. There's another thing I want to say, but I talked to Tiffany about this before the stream. The Fit Lawyer ATL is my co-counsel on the Moonk. I'll talk in a second, Pete. On the Moonk case, and she brought up some interesting points. We're going to talk about it more tomorrow. About the revocation more tomorrow. No, like someone comment. Revocation. Yeah, they haven't filed a revocation, but there should be there could be a hearing on the underlying case, the car thing, the arrest. Yeah, there's no. I don't think they're going to file a revocation for Farley. That case is ridiculous, and they're lying all throughout it. I can cover that more if you guys want to, but so this is about his influence, supposedly. Wait a minute. He didn't even say that. This is just Judge Whitaker talking. Rap lyrics, I understand how it could be twisted. I understand what it could do to the mind of people. I understand all that. I'm changing that. I'm older. I'm grown. Experienced a lot of good things. And then Whitaker talks. She's not... Am I wrong? Let's see. It was... Let me see. Oh, that's dirty. As both the defendant and the court acknowledged during his plea hearing, the defendant wields significant influence over people worldwide. So that part's a lie too. I mean, maybe not a lie, but it's not honest. Wheels, yeah, exactly. Okay, Miles, I guess I knew this. There's not much substance to this. The bottom line to me is there's no actual violation of the being alleged here. It's just they're saying he's a dick, and they don't like him, and they want his probation revoked. That's not a reason. Let me see if I can find... I can do a Miles Farley thing real quick. Let me just pull it up. If you guys have any questions, I can try to... Okay. I don't have any updates from the first... from a couple of... from the arrest. Since the arrest. But let me see. Gotta look through my stuff. Where is it? Is it? That's one. Nope. This one? Okay, I delete my notes. Would you file a motion to terminate probation as a response? I saw GSU posted that. That's a good idea. I mean, now that he gave me the idea, I would absolutely do that. It's a really good idea. I mean, this kind of targeting, they're clearly targeting him, and it's not an honest, genuine attempt at a legitimate revocation. And it's just continued bad faith. I would absolutely do it. And I think there's a real chance that that she would grant that as well. Says he's confident it'll get dismissed. I am as well. Yeah, he did. I saw that. I'll tell you a little bit about why I think it will get revoked, or why it will get dismissed real quick. We'll just go through these two. This is the affidavit for his arrest. This is the first affidavit, and it was filled out by this guy, D.S. Taylor. Oh, man. Anyway, yeah, I'm not going to read the whole thing, or maybe I will. But he says that the events happened on March 6th between 5 and 6 on Hateful Road. That's right off of Cleveland Avenue in Fulton. Did commit the offense of possession of a firearm by a first offender probationer. That's actually the same code section that Moonton's charged with on count 30. And that said accused did have in his possession / wingspan Glock 17. While being... Actually, no, why it says wingspan. That's not part of the statute. But anyway. While being a passenger in a black sedan during a traffic stop. Mr. Farley is on first offender probationer for violating the RICO Act on 12/17/24. That's not when it was violated. That's when he pleaded guilty. But that's okay. A tracking number said, and this deponent makes this affidavit that a warrant may issue for his arrest. Okay. That's not that bad. On March 6th, Officer Taylor... yeah, that's fine. You can text it to whoever. Since others. Special condition number 5. Sorry, I'm jumping back to Young Thug real quick. Oh, yeah, maybe. I could see that. Okay. March 6, 2025, I, Officer G.S. Taylor, Unit 1851, along with other Apex units, conducted, we'll get to that in the next one. Remember, they're talking about Apex units. Conducted a traffic stop on Hateful Road on a black sedan bearing a Georgia tag of YXN 504. Marijuana flakes. For the violation of OCGA 48-73-1. I talked about this with Tiffany the other day, but that isn't a law. It's actually, I know it's going to mute me probably, but I'm going to go to the other day, but that isn't a law. It's actually, I know it's going to mute me probably, but I'm going to go to the other day, but that isn't a law. It's actually, I know it's going to mute me probably, but I'm going to go to the other day, but that isn't a law. It's actually, I know it's going to mute me probably, but I'm going to go to the Yeah, that was he was arrested at the McDonald's on Cleveland Avenue that Brian Steele wanted the video footage from. Let's see. During investigation, I saw what appeared to be marijuana flakes, which I made this joke so many times, so I made a joke about it being cereal. But it's crazy that he's just saying he sees marijuana on the console and floorboard. Can you hear it now? Okay. If he was still the trial judge, yeah, definitely possible. I'd be interested to hear what he thinks about the whole trial, with the benefit of hindsight. I mean, you saying it's a city code. Marijuana flicks. Console, floorboard. He Yeah, he said that was based on his training, knowledge, and experience to recognize marijuana flakes. I then asked if there were any narcotics or firearms in the car, to which both individuals answered by saying no. It's funny that he sees weed and then asks if there's any drugs. Based on the information that I gathered, I requested both males to step out of the vehicle so that I could conduct a further investigation. At the same time, let's see, speaking with the males, I had officers request K9 to my location to conduct an open-air sniff of the vehicle. Let me see. Officer Pagan and his dog Jumbo arrived on the scene. There's something added here in the next one. I'm just going to remind myself of that. After conducting the open-air sniff, K9 Jumbo positively alerted the driver's side door of the vehicle. His driver's side door. I then walked over to the driver and advised him on the next step, which was a search of the vehicle based on probable cause. While searching the vehicle, I recovered a Glock 17 inside the glove compartment. Yeah, I don't know where Chloe is. The glove compartment on the passenger side of the car. I mean, that's where the glove compartment is. But remember, the dog alerted on the driver's side. I also recovered one white pill with markings T194 also on the passenger side. I did a Google search on the pill identifier and determined that the pill was oxycodone. Both males were then detained by placing city handcuffs on them. This was also changed. I asked both males who the firearm belonged to, and neither took ownership. They both stated they did not know that it was in the vehicle. I conducted a criminal history inquiry and a status check on both the males and the firearm. I probably wouldn't have conducted a criminal history inquiry on a firearm. But anyway, the firearm came back not on file, while the criminal history revealed that Mr. Miles Farley is on the First Offender Act out of Fulton County Superior Court for violating the Georgia RICO Act. I read Mr. Farley's Miranda rights, and he agreed to speak with me without his attorney present. I asked him about the firearm, and he denied knowing anything about it or being involved with any gun. So this was interesting to me. I read him his Miranda rights, and then he asked him the exact same question that he just asked him previously. Even though he put handcuffs on him already. And he hadn't made a determination as to who owned the gun at this point. Definitely a possible Miranda question there. Yeah, I heard that too, Kels. That seems pretty much everyone said that. And I mean, he was the chief judge even before the case. Let me see. The driver later stated that he would take ownership of the firearm if I let Mr. Farley free, which indicates to me that they both knew that the gun was inside the vehicle before the traffic stop. A, that doesn't make sense. B, knowing that it was inside the vehicle doesn't amount to possession. You need to intend to exercise control over the gun. Just knowing it's there isn't possession. Mr. Farley was placed into custody. Only now was he placed into custody. Not when he was arrested, not when he was handcuffed and read his Miranda rights. Why ask Miranda if you asked similar questions before and after? I think they're trying to say that he wasn't in custody before they read the Miranda rights, but I have doubts about that. He had them get out of the car. He handcuffed them. And then he asked them questions. That's getting pretty close to custody. Especially since they had found the oxycodone already at that point. But it's not 100%, but it's definitely a question. Okay, so this is the second, it's basically the second and the third affidavits. This one is by Jay Storno. He's the affiant. He's the one who wrote this out. He is part member of the gang unit. He was part of the raid on Young Thug's house on May 9th of 22. He did a lot of the inventory for Thug's personal possessions. Some of which, didn't stick around for the entire trial. Let's move this around. Here we go. So this has a lot of extra stuff and stuff. Yeah, I'm not convinced that was just detention. Whether something's detention is... that's the question of law. It's not for the police to decide what's custody and what's detention. Let me see. But it could be right. It's definitely possible that's just detention, but that's a pretty expansive reading of detention, I think. Is accused with gang activity, being associated with a criminal street gang, YSL, a subset of sex money murder, to conduct or participate in criminal gang activity through the commission of a crime. That's actually the same thing we looked at in Thug's revocation, the same section, 1615.3. That's just the gang act. Specifically, a criminal offense in the state of Georgia that involves violence, possession of a weapon, or use of a weapon. The activity involved criminal offense of possession of a firearm by a convicted felon or a probationer, during which Miles Farley was unlawfully in possession of a Glock 17. Mr. Johnson. Mr. Johnson's documented affiliation with YSL, coupled with his presence in a gang-controlled location while armed, demonstrates Mr. Johnson's active participation in advancing YSL's criminal objectives. Possessing a loaded firearm, in furtherance of gang-related activities aligns with YSL's established pattern of using weapons to protect their illicit operations. These actions highlight Mr. Johnson's role in perpetuating gang dominance. And securing the gang's operational stronghold, said, and this deponent makes this affidavit that warrant may issue for arrest. So Mr. Johnson just comes in halfway there inexplicably. Okay, here we go. March 6th, 5:10 p.m. This should be exactly the same as the prior version. It's just the facts that were reported by this guy in the last affidavit, by D.S. Taylor himself. And members of the this is the Apex unit, Atlanta Proactive Enforcement and Interdiction Unit, were conducting proactive enforcement along Cleveland Avenue corridor in South Atlanta. So proactive enforcement. I know. This is another copy and pasting that's funny. This location is well known to law enforcement for its high rate of violent crime and narcotics distribution, particularly criminal street gang activity, primarily controlled by members of YSL. While patrolling the area, Officer D.S. Taylor conducted a traffic stop at Hateville Road. Yeah, they do. Tiffany had to try to find out who Mr. Johnson was. We have a theory, but I can't confirm it. Okay, so this is one of the big changes. On a black Ford Mustang, so it was a black sedan, now it's a Mustang. I guess some Mustangs can be sedans, but it says bearing Georgia tag YHM 162 for a violation of, that's the window tint statute, but not really. They changed the license plate number. It was YXN 504 before, and they switched it to a different car. It's a YHM 162 the next day. This was written about a day after D.S. Taylor wrote his. And it's strange because it looks like, I don't think it's a copy and paste error, because the first half of the sentence is verbatim from the first version. So let me see. I don't know if it's verbatim, but it's the same content. It's conducted a traffic stop, Hateville Road, on a black sedan. Conducted a traffic stop at Hateville Road on a black Ford Mustang. So he had to change this sentence. It wasn't just a copy and paste mistake like Mr. Johnson probably was. This had to have been changed specifically by Joseph Storno. Upon approaching the passenger side of the vehicle, that's also different. Well, let's say Officer D.S. Taylor observed that neither occupant was wearing a seatbelt. In the last version, it was after speaking to them, he noticed that neither was wearing a seatbelt. So that's also changed. It's just different facts. This same officer identified himself and requested ID. During the interaction, D.S. Taylor observed what appeared to be marijuana flakes in lowercase scattered on the center console. Based on training, knowledge, and experience, this raised suspicion of possible narcotics possession. I still think that's ridiculous. He can see it, but he's just suspicious of it. I mean, it's right there. When asked if there were any firearms or illegal substances, both individuals denied possessing any contraband. Given the presence of suspected marijuana residue, that's also a new thing. The word residue didn't come up anywhere in the first affidavit, unless you're saying that marijuana flakes are just residue. But then he should have just said that. Marijuana residue statements, individuals were asked to exit the vehicle, allow for further investigation. A request was made for a K9 unit. Officer Pagan arrived shortly thereafter. That's also not in the, two different places. Also not in the first version. There was no statement as to how long it took the dog to get there by D.S. Taylor. So this is just added. Open air sniff, alerted the driver's side door. I think this is different. Let me check. Yeah. The first version says, I walked over to the driver and advised him specifically on the next step, which was a search of the vehicle. Here he says he advised both occupants that a probable cause search of the vehicle would be conducted. So he's also rewriting the events on that one. During the search, Glock 17 was found. Additionally, a white pill marking as T194 was found on the passenger side floor. A pill identifier search, this one's kind of funny. A pill identifier search confirmed the pill is oxycodone. And the first one, this isn't a big deal, it's just funny to me. Diaz-Taylor phrased it as, I did a Google search on the pill identifier, which is probably the same thing, but just saying a pill identifier search makes it sound a lot more official, I guess. Anyhow, both individuals were immediately detained. When questioned about the firearm, neither claimed ownership, both stating they were unaware of its presence. A criminal history check was conducted on both individuals, along with the status inquiry on the firearm. Firearm wasn't on file. That's not a bad thing. There is no file in Georgia on firearms for the most part. If it's not on file, that's not a bad thing. That's usually a good thing. However, the background check revealed that Mr. Farley was on first offender, given the December 24 RICO Alfred plea. Diaz-Taylor read Mr. Farley his Miranda rights, which he acknowledged and waived. Going to speak without an attorney, never do that. When asked about the firearm, Mr. Farley denied any knowledge of it or involvement with firearms. However, Mr. Farley was seated in the front passenger seat directly adjacent to and within arm's reach of the glove compartment where the firearm is located. So he's... let me just finish this section. Given his close proximity and ease of access, it was determined that Mr. Farley had constructive possession of the firearm. Further supporting his conclusion, Mr. Greer later offered to take responsibility for the firearm in exchange for Mr. Farley's release, an action that strongly suggested both individuals were aware of the firearm's presence before the stop. So here too, no, I'm sorry. So he's saying that it's constructive possession, that he, although it wasn't on him personally, that he had access to the gun and therefore he possesses it. But there's nothing suggests you need to, being close to it isn't enough. You need to intend to exercise control over it, and it needs to be yours and exclusively yours. And it's just near him. It was in the glove box. They're trying to make it seem like it's under his control just because it's close. And they're manufacturing this stuff about because the driver said he'd take responsibility for it. That means that the passenger is responsible for it. That's insane. And yeah, there's just nothing there. Based on the totality of the circumstances, including the location of the firearm, Mr. Farley's criminal history is one count ever, and the exchange between the two occupants, I don't know what that is. Maybe he means offering to take responsibility, but I don't think that's the same thing. Mr. Farley is placed into custody and charged with possession of a firearm by a first offender probationer. Mr. Farley would later be transported and booked into Fulton County Jail. The recovered firearm is booked into evidence. One thing that's interesting, so this is supposed to be between 5 o'clock and 6 o'clock. The arrest ticket given, where is it? I haven't looked at this in a while. Oh, here it is. Where did I put you? Oh, yeah. So the official report, they gave her an arrest time of 9:11 p.m. So there's got to be several hours unaccounted for there. And then after the arrest time of 9:11, he's not actually booked into jail until 5 in the morning. So about 8 hours later. Lots of drama. And there'll be more soon, I promise. But yeah, there's just a lot of time that's unaccounted for. The K-9, the addition of the K-9 promptly arriving in the second affidavit is incredibly suspicious to me. It seems like they're trying to get ahead of something. I'm trying to. Anyway, that's just some of the stuff that I saw in this It's it's very thin. There's no, especially the possession. I mean, he was close to it, but that's nowhere near good enough, in my opinion. Trying to find this section. Where is it? Is the second one? Ah, here it is. This sentence was my favorite that I hate the most. Yeah, of course. This is the last thing. I gotta eat some dinner soon. Yeah, I'm sure there's an interrogation. I mean, it's possible, but there are specific facts that are changed, though. I mean, the license plate, if nothing else, is just completely different. Anyway, given its close proximity and ease of access, it was determined that Mr. Farley had constructive possession. Who determined that? And A, and B, that's not something that they get to determine. Yeah, that's right. I did talk about this with Tiffany, and I actually made that same thing, that same comment. It sounds like a smoke at the Solly port. Exactly. But yeah, the it was determined is that alarms, red flags, sirens, whatever you want to call it, whenever they switch to passive voice and say something like that, it's suggestive that them not being sure of, or being uncertain in their conclusion. If they really believed it, they would say he constructively possessed a firearm because of A, B, and C. I don't know about approving sergeant. It was signed off on by a judge. And that's actually a good point. This report was the one that got into Mr. Johnson, which is pretty bad. But yeah, it's just a mess. And I mean, we can't go through all this stuff right now, but it's a lot of gang talk that was already resolved in the first trial, and it's not really relevant to to any sort of ongoing connection between him and the gang. They would need something to actually tie him to the gang since his sentence was imposed. Yeah, I don't know. I'm definitely interested to see what happens. This one in the Martinez Arnold, the Duke, civil forfeiture cases are super interesting to me, and there will be news soon on some other stuff. And definitely interested to see how this Young Thug revocation goes. I don't think much is going to come of it, but if it gets all the way to a hearing, I will be very, very happy and excited about that. I can only imagine. Storno's an investigator, though. I don't know if he has somebody between him and the judge. Like, we know Viverito went straight to the judge. He's a gang unit detective investigator, something like that. Oh yeah, that's right. Forgot about that. Adventuring. That's right. He pleaded. This was the offered plea to the conspiracy charge. This conspiracy count. But yeah, I need to go back to working on some stuff that is related to probation. So I'm going to wrap this up, get some dinner, and I'll try to get back soon. This was fun. I hope everything worked technically. Checking this stuff, and yeah. I'll see you next time.